the human bomb killed Rajiv Gandhi on spot. The actual killer died on the spot. 50,000 people witnessed that killing. And yet when the matter came to court, our SIT went to the first conspirator, those who supplied the vehicles, those who supplied the arms, those who supplied the shelter, those who harbored them, those who planned the conspiracy. Our SIT got all of them. The SIT did a remarkable job in reconstructing the whole crime. And finally the SIT found, just as we don't have any eyewitnesses of what happened in Karachi or the terrorist training camps, the SIT did not have any eyewitnesses of what the conspirators were doing behind closed doors. Conspiracies are hatched in darkness. They are behind closed doors. They don't leave eyewitnesses behind. So it's only when the first conspirator sang, the second conspirator spoke, that their evidence under TADA became admissible evidence, and the conviction of the other accused in the Rajiv Gandhi assassination case took place only because of the admissibility of those confessions. Take those confessions out and this country would have been a laughing stock, where a former prime minister is assassinated in front of 50,000 people and you wouldn't have had a conviction in the case. The actual assassins had died on spot. Take the parliament attack case. The 5 actual persons who attacked Indian parliament died within this premises itself. It's the conspirators who were arrested. And the most material evidence against the conspirators is a lot of what some of them, the first man and the second man who were arrested, those who spoke. Now it's always been said, and this is not only in this case, and I'll come to it a little later, what is it which is required in a strong anti-terror law? And I always tell my friends in the government, when India is on the terrorist radar, you don't have to be apologetic about India having a strong anti-terror law. We are supporting this government on this anti-terror law. But the difference between the ruling benches and the opposition this time is, the opposition is supporting this bill as a national necessity. The ruling party is still embarrassed and is apologetic about having brought this bill. That's the difference. It's a strange dichotomy in Indian democracy which has taken place. We are more enthusiastic about what the government is about bringing a law of this kind. Now you require an anti-terror law. The government repealed POTA. But then their security experts told them, why are you making India so vulnerable? Sir, I did an exercise as to what was there in POTA. Of course, I know, I'm conscious of the fact that such a remedy is not available. But if for hijacking or copying an intellectual property, an action was available, I think the NDA had a strong case against the UPA. We drafted a law, they said it's a horrible law, we will repeal it. And then took a scissor and a pasting exercise and started sculling out provision by provision from POTA, and word by word, full stop by full stop. And if we had left a grammatical mistake somewhere, along with that grammatical mistake, started incorporating it in the Unlawful Activities Prevention Act. I just started comparing the features, the language, the verbatim, the language are the same. The law must define terrorism, so they repealed POTA, which defines terrorism. They picked up that definition and put it in the Unlawful Activities Prevention Act. POTA was criticized because it had an extraterritorial application. Obviously it's needed because if one limb of the conspiracy takes place in Pakistan, an anti-terror law will necessarily have an extraterritorial application. So you brought it back by the 2005 amendment. The quantum of punishment required under POTA, you picked it up and brought it back. Now, besides an act of terrorism, we said whoever abates terrorism, whoever incites terrorism will also be an offense or a lesser offense. They picked up the language, pasted it in another law. Harboring terrorists, picked up and pasted in another law. Membership of a terrorist organization, again picked up from quota, verbatim put in another law. Confiscation of proceeds of terrorism. Now this was based on a salutary principle that no person can benefit from profits of crime. You commit a crime and out of the profits of that crime you buy a house or you open a bank account or you keep money. So the properties will be confiscated if they are out of terrorist funds, or those will be confiscated. They said, very good concept, let us put it back. If you threaten witnesses in a terrorism case, that also is an offense. Verbatim taken and put in the act. Declaration of an organization as a terrorist organization. Picked up the provisions verbatim and put it in the other act. Special procedure, special laws, picked up the procedures, picked up the sections, placed them in another act. And then, let me compliment, the Home Minister is not here, Mr. Sibal is here. And Mr. Sibal's favorite argument is that my law is better than your law. So the remand period we provided, Mr. Sibal's argument, which I have answered for the last 4.5 years, was a special law is not required. Mr. Sibal is a man of principles. You see, he opposes it on Republican principles. He brings this law back on principles of preserving national sovereignty. In any case, he stands by those principles, and he will justify his principle at all stages.
For national sovereignty, as you know.
Yes.
Republicans are not against national sovereignty.
But I think in that event, with all these provisions had to be brought back,
You know the Republicans around the world.
if all these provisions had to be brought back, there was no need why India should have been made so vulnerable for 4 years and 7 months.
That we will tell you at the proceeding.
For 4 years and 7 months, you made this country vulnerable, and then you decided to bring the same law back. Then, sir, the law said, well, there is a remand period mentioned in the old law. We'll now have a discretion for a larger remand period. Well enough, because if the investigation does not conclude in 90 days, you may require 180 days. And therefore, you may require to get evidences internationally, you may have to send letters of entries across the globe. To get evidences, you may have to deport people from other countries. Therefore, longer periods of investigation will be required. And therefore, they put a provision giving some element of flexibility. Yes, longer remand is required. It's a correct provision in law. I have no difficulty with that. On dozens of occasions, we've been told in this house, you turned the law upside down by shifting the onus of proof. There are no presumptions which are available. Now the presumptions available in POTA have been exactly brought back. And what are those presumptions? The Evidence Act has those presumptions. There is a chapter for presumptions in the evidence law. Well, if a weapon is found in your possession, the presumption is it is yours unless you disprove the fact it is not yours. If your fingerprints are found on a vehicle, on the steering wheel of a vehicle which is used for a terrorist offense, the presumption is you have used that vehicle. The onus is on you to prove that you had not used that vehicle. The section number has been altered, sir. That presumption now is back. Confiscation of passports, setting up of review committees. In fact, POTA had a very interesting safeguard with regard to intercepts. Obviously, a large part of criminal law investigation these days is done on the strength of taping telephonic conversations and intercepts. Now, doubt arose whether these are admissible evidence. But POTA provided a safeguard. The safeguard under POTA was, if a police officer wants to intercept, then from the competent authority he must take sanction. And every fortnight the review committee headed by a judge will certainly get the total record of whatever and the people whose intercepts have been made. And these intercepts will be admissible evidence in a court. You went a step further. You said no sanctions are required. The intercepts from wherever you get are admissible evidence. Well, the police was facing a difficulty. If you want to go that far, I have no difficulty. We'll support you even on that. But don't be apologetic about the fact that India didn't need a strong anti-terror law. It's an admission of the fact that you made this country vulnerable for 4 years and 7 months. And now you've come back to say, well, India does need a special law. You can't fight terror with ordinary laws. Sir, there were 2 vital provisions left out. And the 2 vital provisions are, one with regard to a special bail provision, and the second with regard to confessions. So as far as bail provisions were concerned, under your normal criminal law, you have the bailable offences, the non-bailable offences where the discretion is with the court. There are special laws in which the discretion of the court in granting bail is further reduced. The court can't grant bail till a public prosecutor has been noticed. And if the court comes to an opinion, at the stage of bail, that prima facie the case is true, or prima facie the case is not false, just a prima facie case view, the court will not grant bail. Now this provision, we had been repeatedly saying you require a stronger provision, because once a terrorist gets bail, and if he is an international jihadi, after getting bail he is not going to come back and say, well, I am coming back for the purposes of getting executed in India. So he certainly is going to jump bail. Therefore, why do you not have special provisions with regard to bail? Now the present law has brought that provision back, but then the UPA is not NDA, so you have to be different. So the earlier law said, prima facie the case against him is not true, the judge will grant bail. You said he will not grant bail if he is proved that prima facie the case against him is true. So one had a direct mention, the other alternative as double negatives. The two mean exactly the same. So you said, well, we have a different bail provision now. And you brought back, and there is nothing wrong with this bail provision. Sir, I have just prepared a list. Tata had this bail provision, Pota had this. But besides an anti-terrorism law, there were other laws in India. There are at least 12 laws in India which have the same bail provision. The Makoka has the same bail provision. The Andhra Pradesh and the Karnataka organized crime laws have the same provision. But then the government said we are against these organized crime laws, so we are not allowing some BJP-ruled governments to have those laws. But your Narcotics Act has the identical bail provision. Not only the Narcotics Act, I have copies, sir. You have similar bail provisions besides the Narcotic Drugs and Psychotropic Substances Act, Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act, Anti-Hijacking Act, Prevention of Damage to Public Property Act, Prevention of Money Laundering Act, and then even suppression of unlawful acts against safety of maritime navigations. You have the same bail provisions, which are those extraordinarily hard bail provisions. Suppression of unlawful acts against safety of civil aviation. Terrorist affected areas Special Courts Act. And finally, even the Wildlife Protection Act. So those who commit these offences against wildlife would not get bail. But those who committed these crimes against humanity, terrorist offences, were entitled under this government for 4 years and 7 months to lighter bail provisions. And they said, no, we won't have it. Finally, I think where all our logic and rationality failed, you have those 10 evil men who came on 26/11, convincing the whole country and then pressurizing this government to reluctantly come up and strengthen the bail provisions. Even confession, sir, on the face of it, it may look a little alarmist. concede to this that ordinarily in a law confessions to a police officer is not admissible evidence, should not be. That's the normal law. In all our laws, this should be the general principle. Then we in India have exceptions. We in India even today have exceptions. Tada and Pota were exceptions. Makoka is an exception. Karnataka organized crime law is an exception. Andhra organized crime law is an exception. The narcotics law is an exception. You make a statement to an officer investigating a narcotics offense, your statement is admissible evidence. You make a statement to a customs officer, it's an admissible evidence. You have in foreign jurisdictions, in liberal democracies, these statements become admissible evidence provided the judge is satisfied with regard to the voluntariness of the nature of the confession. And the Supreme Court said this is extremely important. If obviously the confession is involuntary or appears to be involuntary, it should be disregarded. But they said, how do you then ensure that there is no misuse? 4 guidelines were suggested. 1, the officer recording the confession must be SP or above. 2, it must preferably be video recorded or audio recorded. 3, within 24 hours or 48 hours as the government decides, the accused must go before a judge after making the confession. The judge will ask him if it is voluntary. If he says it's involuntary, he will have him medically examined. And all these factors will be considered in order to determine the nature, voluntary nature of that confession. Now on one hand, you have an extraordinary crime, and that extraordinary crime is a crime against the state, a crime planned in secrecy, where there will never be an eyewitness. I repeat, those who conspired in secret meetings to assassinate the late Shri Rajiv Gandhi, no investigation could ever produce eyewitnesses of that. One of them had to speak. And if his statement was not evidence, then there would be no evidence. If Kasab's statement is not evidence, then it's extremely difficult for India to prove what happened in the Karachi or the Pakistan limb of this conspiracy. But then, when you've gone so far, why do you stop halfway? When you want to create a national investigative agency, why don't you give it the tooth that it needs in order to investigate a crime and produce before the world and the Indian courts evidence which is required in relation to these crimes? Sir, if these are not, if these essentials are not there, then I am afraid, even though we've moved half a step further, there will be cases and cases where we will still fall short. And there are enough people waiting really to find holes in the Indian case. I am not referring to this as the police case. This is not a case. At times we are in the habit of discussing, well, so many attacks took place when you were in power or when I was in power, or somebody else was in power. This is the Indian case. There are enough people waiting. You had articles written, books written, which said the attack on Parliament was organized by the RNAW and the IB. You have Indians authoring such books, writing articles in newspapers suggesting this. We may all be magnanimous and be willing to pass off yesterday's statement of Mr. Antule merely as an irresponsible act or something where he perhaps did not adequately express himself. But then his statement is huge fuel for the country which has been extending facilities to terrorists in action against India. Read the blogs in Pakistan today.
Good friend cannot mention the name of a person who is not a member of the
What is this?
And he is not here, he is not here. And he's already denied it on the floor of the House.
This is a parliamentary record. Today all the newspapers are carrying that story. What is behind it?
According to him, he has denied it, it seems.
He spoke what ISI had Uncle said, but ISI have been saying it.
Denial compounds it. What he said in the so-called denial, it compounds it, sir.
Sir,
He said, but ISI have been saying.
I think Mr. Sibal is right. I really should not have named him. The government itself should have named him today morning. But this is something which has embarrassed this country. This has weakened our case internationally. Something which defies the collective responsibility of the cabinet. Something which provides ammunition to our enemies and opponents. And therefore, I should not name them. The substance should be the government itself should have come up and shrugged off its any relationship with the person who makes this kind of a
The
statement.
Congress spokesman said that it is his personal view, it is not the Congress stand.
Sir,
He is not denying.
sir, therefore,
He is a member of the cabinet.
sir, therefore,
He has responsibility.
therefore today, on a strong anti-terror law, where are we? The whole country was misled, we don't need a law. The law was repealed. Then, sentence after sentence, clause after clause of that law was brought back. But then you wanted to have that one upmanship and say, well, we are different because this one provision is not there. And that one provision is a significant provision. With safeguards, unless that provision is there, in case after case, you will be weakening India's case. And I reiterate and say, if that provision had not been there in Tada, the accused in Rajiv Gandhi's case would have benefited. If it had not been in Pota, the accused in the parliament case would have benefited. And since that was not there, fortunately Mumbai has Makoka which has that provision. But for some reason I am told, Makoka has still not been pressed into action in the 2611 case. And unless that statement is a statement under Makoka which becomes evidence, the Karachi and the Pakistan limb of the conspiracy may be difficult to establish in law. And therefore we will require to do that. So please reconsider. When you've traveled all this distance and wisdom has dawned on you in the last 5 months of your government, please don't make it an incomplete step. The Home Minister was candid enough to say he had consultations with the opposition. We made it very clear to him that we will come what may, even if it's half a step, we will support half a step. We have our own nationalist credentials and therefore we don't want to stop that half step. But then please make India a strong state. This law per se will not abolish terrorism. Merely because we have an Indian penal code, crime has not ended. Because we have section 302 which provides for death penalty or life penalty, murders have not stopped. Murders are still taking place, but law provides a deterrent in a civilized society. It provides an expeditious methodology of investigation and punishment. And therefore, please give this law more teeth than what exists today. Sir, the second part of this amendment, in the second bill, is the setting up of a national investigative agency. As I have said, as far as the first law is concerned, we have supported it because it's half a step. We have reservations about what's not being done and we'll continue to campaign for that. But as far as the National Investigative Agency is concerned, I have no hesitation in saying that we fully support the proposal as has been mooted by the government. And this is for two good reasons. First, some doubts are at times raised whether central government possesses the power to take over what appears to be a power within the state jurisdiction. So the constitutional entries make it very clear. Defense of India in list 1 entry 1 is the exclusive primary domain of the central government. It's public order which includes law and order, which is the domain of a state government. Where does terrorism fit in? Terrorism is not merely law and order. Terrorism is something which attacks the sovereignty of India, it attacks the unity of India. And therefore, if it's cross-border terrorism of this kind, it has something directly to do with the defense of India. And therefore, even the Supreme Court, when Tada was first enacted and Pota was first enacted, an objection was taken with regard to the legislative competence of the centre to enact an anti-terror law on the ground that the law and order is a state subject. But the Supreme Court also said that there is no entry called terrorism in the Constitution, and therefore this could perhaps come within the defense of India and not public order. And if it doesn't fall in either, then it comes within the residuary entry list 1 entry 97, and therefore this is exclusively within the central domain. To protect the sovereignty of India is a responsibility of the central government, and therefore against terrorism, if a law is brought, it is within the central domain. And if an agency is created to investigate that offense, then obviously those who have the competence to enact a law also have the competence to create an agency of that kind. And therefore we fully support the government's proposal that the central government is fully competent to enact this law. Even otherwise, sir, an offense of terrorism in some cases may not adequately be investigated by a state police. There may be offenses which have an interstate ramification. You may require sharing of intelligence between several states. You may require coordination of intelligence of all those states. You may have different limbs of the conspiracy in different states. You may even have, as this law has extraterritorial application, some parts of the conspiracy taking place outside India, some intelligence required from outside India. Now there may be offenses where all this is not present and the central agency itself may feel the state police can do it. But in an extraordinary case like the one in Mumbai or like the one of the parliament attack, these may be cases where a state police itself may be inadequate to investigate the offense. And by the very nature of the offense, a central agency would be more competent, sir, in order to investigate that offense. And therefore we fully support of the proposal of the central government as far as the creation of a central agency is concerned, with a discretion that some extraordinary offenses of this kind, when they take place, the central agency itself will investigate those offenses. Finally, sir, let us realize, while we are debating this law, this country has paid a huge cost of terrorism. We've lost individuals, we've lost human life, we've lost lives of security personnel. A large part of our national resource gets spent on it. Where there is terrorism, investment is not forthcoming. Your economic resources are diverted to fight terrorism. You may even have a diversion as far as your defense preparedness is concerned, where instead of looking at your borders, you are looking at the interiors where terrorist activities are taking place. Anti-insurgency steps, anti-terror steps at times are strong. Mr. Chidambaram was right when he says we have to do a balancing act between human rights and fighting terror. And therefore there may be some erosion at some stage of individual rights. Harsh combing operations at times lead to alienation of local population. These are all costs we have to pay because of fighting terrorism. And therefore, when this is the kind of cost this country has to pay, I think we need not be, while we should be concerned about human rights and balance them in our fight against terror, but at the same time, we should not be apologetic in a state whose sovereignty is threatened in taking strong anti-terror steps. And therefore, once we have decided, this government has decided that it has a change of hearts, though what we failed to 2 years and 7 months, those 10 men who came from across the border have persuaded them in doing so, that they brought this law. But then, let it be an adequate exercise. It can't be an incomplete exercise. And as I said, we on this side support these measures as one of national necessity. And the government should not be apologetic about having brought any of these measures. Thank you very much, sir.
Yes.